confession, and it is very, very important. Confession, admission, dying declaration, these are very important from both perspective. One from the examination point of view, another is from your overall knowledge, and for learning the skills of the law also it's very important. You can expect one question from dying declaration, one question from confession, and that's why it's really very important, and that's why I'm discussing all these topics in the detail, not in the brief. In our last class we started discussion on the confession, and on that, the first thing, that what is confession, we have discussed. What is confession? It became very important because this term has not been defined, though there are the principles related to the confession from section 24 to section 30 of the Indian Evidence Act, and certain procedural law with respect to the confession in the civil procedure code, like section 163, 164, etc., that we have discussed in our last class. Then the second thing uh, is about that why the confession is relevant, and in what situation, or in which situation, or what is required to be a confession as a relevant. So as such, it's a general uh, principle that no one can make the statement against his own interest unless he is prompted by the self conscience, in the feeling of regret, in the feeling of remorsefulness. And so when a statement is made voluntarily, and that statement, it admit the offense in itself, or at any rate admit all the facts that constitute the offense, so that amount to the confession, and that is relevant. Now, when the voluntariness has gone, then the very essence of the confession also has gone, and so the focus is on to making the confession as voluntarily, deliberate, etc. And so in the section 164 of the CRPC also, it is the duty on the magistrate to ensure that the person who is making the confession, the accused, is making voluntarily, and to even tell him that he is not bound to make the confession. If the confession he is making, that can be used against him. So just this thing is to ensure that it is a voluntarily, it is a voluntarily, because if it is not voluntarily, then it will be hit by the article 20 clause 3, because article 20, that have three principle, if you remember. One is the double jeopardy, another is about the retrospective of non-retrospective of the criminal law, and third is about the self-incriminating statement. So article 20 clause 3 says that no person accused of any offense shall be compelled to be a witness against the himself. And when the person making a statement, making the confession, that is not voluntarily, that means by compulsion, then it is the violation of article 20 clause 3. And so section 24 of the India Evidence Act is actually in line with the article 20 clause 3 of the Constitution. It is the extension of the article 20 clause 3, like the double jeopardy principle we have in the Constitution. And similarly, there is the section 300 in the CRPC, that is the extension of the double jeopardy principle available in the Constitution. So similarly, it is the extension of article 20 clause 3, and that's why the focus is on the voluntariness. Okay, now the next thing I'm taking today is that mere conduct is confession or not. Now, you can write it as a headline, also, that whether conduct of a person constitute confession or not. conduct may be of in highly incriminating nature, whether that amount to the confession or not. Yes, guys, please tell me whether conduct of an accused be treated as a confession, or conduct can be amount to the confession. Like the conduct like that, after that incident, the person absconded from the place, or some other type of the conduct that he was cleaning his house. There was blood stain and he was cleaning his house. Um, he was burning clothes, etc., where there are blood stain on those clothes. So whether these type of the conduct would amount to confession or not. Yes, guys. Nancy, Miss Nancy. Srasti Sri. Whether incriminating conduct amount to confession or not. Ajay Kumar Gond. Ajay Kumar is saying that yes, it amount to confession. Abhimanyu, Mr. Abhimanyu, what do you think? Whether incriminating conduct would amount to confession or not?
No, sir, it should not be.
Okay, Ramkaran. See the simple example that after commission, the murder was committed in a locality, and to the next house, the person who was, the people have the suspicion on him, and after the commission of the crime, he was washing his all the clothes. He was burning his clothes, washing his house, and then he absconded. Like these type of the facts, these type of the conduct. Arsadis, I don't think it would amount to confession. However, it treated it. Yes, great. Yes, Ajay, I expect that you answered, but think it in broader light. The confession, section 24 to 30 fall under the group of admission, and section 17 admission says that admission is a statement. So there must be assertion होना चाहिए. आप मुंह से बोले या आपने किसी चीज पे डॉक्यूमेंट पे लिखा हो, बट assertion is necessary, statement is necessary. A confession is species of the admission. So admission, how the confession is different from the admission, that admitting something, some fact is the admission, and admitting all the offense or all the fact that constitute the offense is confession. And so the conduct cannot be treated as a statement. Conduct is not an assertion. And so highly incriminating fact that the person who run from the house of the victim, then he burned his cloth, because that give the indication that might be his cloth is draped with the blood. Then he washed his house and then he absconded. These things may amount to the certain other type of the inference, but it would not amount to the confession, because that it is not a statement, it is not an assertion. And so to amount a confession, the act or the conduct must amount to the assertion, and because it is not assertion, so it is not a confession. So these any type of conduct that giving the inference towards the involvement of the person in the crime or highly incriminating inferences is also would not amount to the confession. Then the next thing is the uh, you know this Article 20 Clause 3. Confession is an admission of the guilt, and normally nobody would like to admit his guilt as he is fully aware the same would be used against him. And thus, apart, there is a constitutional right for the accused that he shall not be subjected to the testimonial compulsion. Under Article 20, Clause 3 of the Constitution, the accused person has the protection from being compelled to witness against himself. And so, the confession in which there is force of the compulsion by any means, by the threat, by the promise, etc., or you can say when the confession is not the voluntarily, so it is hit by 24. And even if it is not covered under the section 24 also, such type of the confession that would be hit by the article 20 clause 3. So that is the applicability of article 20 clause 3 in the confession. Now come to the next thing is that types of the confession. See, confession can be divided into two categories. One is the judicial confession and another is the extrajudicial confession. And the judicial and the extrajudicial confession both have the different, you know, evidentiary value. The evidentiary value of the judicial confession is much larger because the person who is recording the confessionary statement is the magistrate in itself. And the magistrate has to follow the procedure that has been established under section 164 of the Criminal Procedure Code 1973. And so there is a greater value. Moreover, the magistrate is duty bound to ensure that the confession is voluntarily without any force, and he has to ensure by explaining to the accused that he is not bound to make the statement and it may be used against himself. In the extrajudicial confession, such type of the protection is not there, such type of the precaution has not been taken. And so at the evidentiary value, the extrajudicial confession is much lower in comparison with the judicial confession. The first thing is that what is the judicial confession? A judicial confession is basically the confession before the judicial magistrate during uh, you know the during the inquiry, during the trial, or during the inquiry. Here there is one important case, state and city of Delhi, National Capital Territory versus Navjot Sandhu. The Supreme Court observed that the confession are considered highly reliable because no rational person would make the admission against his interest unless prompted by his conscience to tell the truth. However, before acting upon the confession, the court must be satisfied that it was freely and voluntarily made. A confession by hope or promise of advantage, reward, or immunity, or by force or by fear induced by violence, threat of violence, cannot constitute evidence against the maker of the confession. The confession should have been made with the full knowledge of the nature and the consequence of the confession. And court has to satisfy that it has to be made at voluntarily, and at the stage the question whether it is true or false does not arise. At that stage it has to be made. So the judicial confession is the confession made by a person before the judicial magistrate, and it has to be you know, during the investigation before the trial. Okay, so that is the nature of the judicial confession. Now, the evidentiary value, as the Supreme Court has said in the NCT, State NCT of Delhi versus Navjot Sandhu, that three things, or you can say that voluntariness, and that it was made with the free will after the person is knowing that it can be used against himself. After assuring these things, if a confession is proved, then that can be even the sole piece for the conviction. Okay, because the question that whether the confession is trustworthy or not, that is the reason that how much evidentiary value is given to the statement. Ah, I'm coming again. See, the confession has two dimensions. One, that it is made with voluntariness, without any type of the fear, any type of the promise, any type of inducement, any type of the violence. Okay, and the second is its trustworthiness, because the evidentiary value means how much trustworthy the court will treat it. If the first thing is assured, that means if it is assured that it is voluntarily, it is freely made, and it was made even after the direction, even after this explaining that he is not bound to make the statement, and it can be used against himself without any fear, without any inducement, promise, or the violence, then thus the rule that no one make his statement against his own interest unless he is prompted by his conscience, that will come into the force, and it will be treated that it is trustworthy. When we treat it as a trustworthy, that means it has greater evidentiary value, and it can be used as a sole basis of the conviction. Okay, now come to the second type of the confession, and that is the extrajudicial confession. First, we will discuss that what is the extrajudicial confession, and the next thing is that what is the evidentiary value of the extrajudicial confession. So, extrajudicial confession means that a confession, whether it is oral or documentary, because that is clear from the definition of the admission under section 17, when the person making the confession not before the judicial magistrate or during the investigation, if that is made, then such type of the statement would be known as the extrajudicial confession. Now, after the commission of the offense, if the accused you know, tell the whole story or make the confession, because before the, you know, the mukhya of the village, before his brother, before his father, or before some other person, would amount to the extrajudicial confession. Now, the question is that how much evidentiary value is given to the extrajudicial confession. The evidentiary value of the extrajudicial confession is very less. It is the weak type of the evidence. And why it is the weak type of the evidence, you have to understand it. Because the very essence of the confession is that it has to be made voluntarily. What we have said, that no person would make the statement against his self interest unless he is prompted by his self conscience. And when the person by any fear, pressure, violence, inducement he is making, we cannot say that this statement is because he is prompted by his self conscience, but rather by the use of those inducement by force, etc. And so, in the extrajudicial confession, we cannot assure the court cannot assure that it is freely made, it is voluntarily made. Because in the state of NCT Delhi versus Navjot Sindhu, the Supreme Court have observed that first we have to assure that the statement is made voluntarily, it is made freely, without any type of fear, without any type of inducement, violence, etc. And in the extrajudicial confession, we cannot say, there is no assurity, there is no guarantee that the that he has been explained that he is not bound to make the confession, or it may be used against himself. And in light of these situation, the extrajudicial confession is seen as a weak piece of the evidence. There is a famous case that came, Nanavati case, where the that Navy officer has killed the paramour of his wife. So, in famous Nanavati case, a statement made by the accused Nanavati to the chokidar of the building immediately after the shooting was held to be the extrajudicial confession and treated as a direct piece of the evidence of the guilt of the accused. An extrajudicial confession has to be inculpatory and must give the substantial detail of the manner of the commission of the offense. Because how much statement would amount to the confession, again we have to go through the Pakla Naran Swami and Palvinder Kaur, that either admitting the offense at, in itself, or at any rate admitting the all the constituent fact of the offense. And so in the confession also, the manner that how the offense was committed, that the detail has to be disclosed by this. So in KM Nanavati, the statement made by the Nanavati to the chokidar was held to be the extrajudicial confession. How much value it has, I'm coming on that point. To the evidentiary value, as we said, that because there is no assurity, court cannot assure that there was no force, there was no other type of the fear or inducement. And this was the statement after explaining that he was not bound to make, and it can be used against himself. The evidentiary value of an extrajudicial confession must be judged in the fact, the situation obtaining in each case. It would depend not only on the nature of the circumstance, but also the time when the confession had been made, and the credibility of the witness who testify thereto, that who is telling the account, or the true account of that confession. So how much that person is reliable, on these facts its value depend. The Supreme Court has observed in the state of Rajasthan versus Rajaram that extrajudicial confession, if voluntarily and true, made in fit state of mind, can be relied upon by the court. The confession will have to prove like any other fact, and the value of evidence as to the confession, like any other evidence, depend upon the veracity of the witness to whom it is made. And so in the extrajudicial confession, the whole value also varies from the person who is actually now giving the testimony, that against whom the confession was made. The veracity has to be checked. And when the cross examination etc happen in that to that person, so in that cross examination, the veracity of that truthfulness of that person is the checked. The If there is any delay, the person who is stranger, sometimes the person who is stranger, if that is also, it is assured that the person is the truthfulness, then that can also be used. But it cannot be the sole basis of the conviction, and it has to be corroborated with the some other piece of the evidence. It has to be seen as a piece of the evidence. As such, you cannot say that it is inadmissible. It is admissible, extrajudicial confession. It is admissible. It also have the evidentiary value, but it has the less evidentiary value, and the whole the truthfulness, whole veracity of the confession depend on the truthfulness of the witness who is giving the testimony of the this extrajudicial confession. So this is the extrajudicial confession. Now come to the next thing, and that is uh, exculpatory statement and inculpatory statement. See, one example I'm telling you, and then you have to tell me that whether it is confession or not the confession. There is one accused A, and he, you know, uh, tell the he gave the statement that on the March 20, 2021, I went to the house of Mr. X with the intention to commit theft, and then uh, I usually have knife with me also. Then there was a situation, and it happened that the person X saw me, and he want to kill me because I was in his house. And then in the self defense, I stabbed Mr. X, and because of that he died. Now the question is, or you make it simple, that A says, or A make the statement that he stabbed X or he killed X, but in the self defense. So whether this statement is confession or not confession. Yes, guys. A gave a statement, or you can say A says that I stabbed Mr. X 3 times, I stabbed Mr. X, or you can say I killed Mr. X, but it was in the self defense, it was the act of self defense. Whether this statement would amount to the confession or would not amount to confession. Yes, guys, please
Yes, sir, it
apply.
would amount to confession.
Kasim, it's amount to confession.
Yes.
Okay, but your brother Arshad from your class saying that it does not amount to confession. Another student Arshad, are you saying that not amount to confession?
Sir, he confessed proper,
Okay,
whether it's A or X.
okay, good, good. Yes, other student also, please answer it. कुछ नहीं, क्या होगा, गलत हो जाएगा तो आपका क्या हो जाएगा, यहाँ तो गलत सही का क्वेश्चन ही नहीं है. यस, सृष्टि, कन्फेशन होगा या नहीं होगा ये?
So it will not amount to confession.
Okay, good. Mr. Susil Rathore. Yes. So you guys were, on the right track, that it does not amount to statement. When the person who is making, you can say, the confessionary statement or the confession, when the person is not admitting his guilt, okay, so that part in which he is not making it guilt is known as exculpatory statement, and the statement in which he is accepting his guilt is known as inculpatory part. So here this exculpatory part where he's saying that I did in the self defense, he is denying his guilt. And because he is denying his guilt, it is not an offense. If you go to the definition of the confession, either he has to admit the offense in itself, that I committed murder. He's saying that I killed, but it was in self defense. And the second thing is to constitute, at any rate, to accept all the facts that constitute. So, what are the facts that constitute the offense of murder? That there was a stabbing, it was with intention to cause the death, there was no exception. So, all these things comes under it. When he is taking the exception, that means he is denying his guilt. Yes, I stabbed, but that was in no self-defense. I was not intended to kill him. Okay, and so a confession being an admission made by a person stating that he committed the crime. The exculpatory statement denying the guilt are not confession and therefore not within the present rule of exclusion. Thus, where an accused admit the killing but assert that it was done in self-defense or some other situation, it does not amount to confession. Okay, the statement that he was not there, the plea of alibi if he is taking, etc., that would also not amount to the confession. Now take the example, the Palvinder Kaur. The Palvinder Kaur was the state of Punjab. The important case, we many time I referred this case. What happened in this case? Palvinder Kaur was the state of Punjab, AIR 1953 SCG. That the accused, this Palvinder Kaur, religion में होता है ना, सिंह मतलब male and the kaur means women. So Palvinder Kaur was accused of charged for murdering his husband, her husband, by administering poison, potassium cyanide. And potassium cyanide is used for developing the photo. At that time, अभी तो कैमरा से सब लोग खींच लेते हैं, उस समय फोटो डेवलप करके फिजिकल फॉर्म में होती थी. So in her confession, the accused stated that she had kept the potassium cyanide, which was a material for developing photos, in the almirah by the side of medicine bottle of deceased, and her husband, deceased, took the potassium cyanide by mistake. The High Court accepted the inculpatory statement that she put the potassium cyanide in the almirah. This whole statement, that is known as, that is termed as the confession, it has inculpatory part and exculpatory part. Now, where there is an exculpatory part, we say that it does not amount to the confession. And court cannot exclude exculpatory part and accept the inculpatory part. Either you have to accept the statement as such, or you have to reject the statement as such. Okay. And so the High Court accepted the inculpatory statement that she had kept the potassium cyanide bottle, but rejected the exculpatory part, that taking it by the deceased through mistake. And then, later on in the Supreme Court, Mahajan judge observed that court thus accepted the inculpatory part and rejected the exculpatory part. In doing so, it contravened the well-accepted rule regarding the use of confession and admission, that it must either be accepted as whole or rejected as a whole, and that the court is not competent to accept only the inculpatory part while rejecting the exculpatory part as inherently incredible. And so, what is an inculpatory part? Inculpatory statement, the statement in which accused accept his guilt. And the exculpatory statement means the statement in which accused denies his guilt. When the confession, that termed as a confession, or when the statement has both inculpatory part and exculpatory part, Like I killed, but it was in self-defense. I put the cyanide bottle, but my husband, uh, you know, uh, take it by mistake. So this statement that has both inculpatory and exculpatory part, in that case, the rule is that the well accepted rule of is that either the confession has to accept it as a whole or has to reject it as a whole. When in a confession, there are two statements. Some statement are mm, accepting the certain fact of the offense, and some other statement are denying the guilt of the accused, then rejecting the denying the guilt of the accused and accepting the inculpatory part is not the proper. And so high court ruling was overturned. So that is the you know law related to inculpatory and exculpatory. See, all these terms would be used when you will read the cases, when you practice in the court, when you become the judges. So these type of the terminology will be used. And then, because the law of evidence is not only up to the sections, you will see confession to define in here, ये सारी चीजें भी नहीं define है, retracted confession etc. You will not find. So these things we have to discuss in the detail. Now the next thing is this, yes, acknowledgement of subordinate fact. When the statement having the exculpatory part or the statement is not clear with respect to some portion of the fact of the offense, then it would not amount to the confession. Highly incriminating, gravely incriminating, conclusively incriminating admission would not amount to the confession. And so that type of the statement is known as the subordinate facts. So acknowledgement of the subordinate fact by reason of the decision both in Paklanaran Swamy versus Palvinder Kaur, it is now well settled that acknowledgement of a subordinate fact not directly involving guilt is not a confession, and thus the mere admission of the person presence at the time and the place of the crime by itself is not confession. The correct test to determine whether a statement is an admission or confession is to examine the statement as a whole and to see whether it amount to the admission of guilt or substantially all the fact which constitute the offense. If it does, it is a confession. If it does not, it is not. It is only when an accused speak with animus confitendi that his utterance became a confession, and thus a statement which is not a plenary admission of the guilt is not confession even when it suggests an inference. And such type of the statement which does not amount to the confession is known as the subordinate facts. Okay. Now to come to the another thing is about the retracted confession. Retracted. First, the person made the confession, and after that, during the trial, he retracted. No, I did not made, or I was forced to made, or it was there was an inducement. That's why I made the confession. There was violence. Police has torture on me. Then that's why it was a confession. So, what is retracted confession, and how much evidentiary value has the this retracted confession? That is our next thing for today's discussion. See, sometime an accused retract from his confession what he has made during the investigation to the judicial magistrate etc, and the confession that is recorded now he is retracting his resile from his confession. So such confession is known as retracted confession. In the committing the magistrate court or in session court, generally where the accused adhere at trial to a previous judicial or extrajudicial confession, it may, if the court believes it to acted upon without corroboration. So this is known as the retracted confession. That retracted confession is such confession where accused regile from his confession which he has made previous, either as a judicial or the extrajudicial confession. Now, the second thing is the rule of prudence in case of retracted confession. And again, there are two cases. One is the state of NCT of Delhi versus Navjot Sandhu, and another is Plani Swami versus State AIR 1986 Supreme Court. Plani Swami versus State. Plani Swami versus State AIR 1986. In these cases, it was held that the retracted, with respect to the retracted confession, it is settled rule of evidence that unless a retracted confession is corroborated in material particular, it is not prudent to base a conviction on the strength alone. That means only on the retracted confession the conviction cannot lie. But when the retracted confession is coupled with or corroborated with some other fact, and corroborated here means corroboration of material particular. Corroboration does not mean with every fact that constitutes the crime the corroboration is required, but corroboration of the material particular, if that is there, then it would be fit for the conviction. And so where there is only his own retracted confession as against the accused, and there is no independent evidence to corroborate his confession, it is unsafe to convict the accused solely on the basis of the retracted confession. Retracted confession without independent corroboration cannot sustain conviction. And then in another case, Pyarelal Bhargav versus State of Rajasthan, the 4-judge bench of the Supreme Court has decided that what the evidentiary value the retracted confession has, or whether the retracted confession can be the sole basis of the conviction without the corroboration. And the Supreme Court in the Pyarelal Bhargav versus State of Rajasthan said that retracted confession may form the legal basis of conviction if court is satisfied, first, that it is true and was voluntarily made, and second is that it is with corroboration. So the confession must be true and voluntarily made, and the second is it must be corroborated with some independent evidences. So if these two things are there, then the retracted confession can also be the legal basis. But retracted confession in itself cannot be sole basis. अपने आप में एक sole basis नहीं हो सकता. बट अगर और एविडेंसेस है कोराबरेटरी, तो हाँ, फिर ये रीजन आपका हो सकता है कि कन्फेशन भी था. बट वो रिट्रैक्टेड कन्फेशन भी आपको विद रीजन लिखना पड़ेगा that it was voluntarily and it was true, because the very question that accused is denying this confession, because it was, ऐसा तो नहीं कहेगा कि नहीं मैंने तो बना दिया लेकिन अब नहीं मानना है. He will say that it was by force, it was by violence, it was by any type of other thing, and that's why judge has to say that it is because it was true, because it was voluntarily. But because the accused is retracting, so there are some other evidences also that support his version, support his confession version, and that's why he is convicted. Now, this rule that retracted confession can be a legal basis, but it cannot be the sole basis. It is not rule of law. ऐसा रूल ऑफ लॉ नहीं है, ऐसा कोई नियम लिखा हुआ नहीं है, ऐसा कोई नहीं है. But it is only the rule of prudence. It is only the rule of prudence, because the cardinal principle of the criminal law, that proving the guilt beyond the reasonable doubt. And when there is only the confession, and that was also retracted by the accused, then it cannot be the basis that reasonable doubt comes in the mind. So that is the reason that it is not the rule of law but the rule of prudence, and it cannot even be laid down in the inflexible rule of practice or prudence, that under no circumstances such conviction can be made without corroboration. For the court may in particular case be convinced of the absolute truth of the confession and prepared to act upon it without corroboration, but it may be laid down the general rule of the practice that it is unsafe to rely the confession. So maybe in some situation where the truthfulness of the confession is clear, in that case, but it is rule of prudence, it is generally unsafe. Okay, so that is the value of the retracted confession. Now come to the section 24. And in section 24, certain words are used. The first is about that it appears. I'm reading it again, so that would be clear to you. Yes, just give me 1 minute. Section 24, confession used by inducement, threat, or promise when irrelevant in criminal proceeding. A confession made by an accused person is irrelevant in criminal proceeding if the making of the confession appears to the court to have been caused by inducement, threat, or the promise. So, what is the meaning or what is the value of this word that appears to the court? See, before that, you have to understand that the confession was voluntarily, confession was free, confession was not without any type of the fear, violence, etc. This is the duty on the prosecution. Prosecution has to prove that this confession that they are proving is voluntarily and free. Okay, here this word used in section 24, that appears to the court that it have been inducement, it has been caused by inducement, threat, and promise. That means there is lower burden, that means it has the lesser degree of probability. Even if it appears, it's not saying that the defense has to prove that it is there was a threat, there was a promise, or the confession was made because there was inducement or threat. So that burden is not there. There is lesser degree of probability that would have been necessary if proof had been required. So the duty is on the prosecution to prove that it was voluntarily and the free. But if the defense even able to create a doubt in the mind of the judge, and then judge think that yes, it appears that it was caused by inducement, in that situation, even under section 24 can discard this. And so this word appears to indicate a lesser degree of the probability. The word appears is an important in importing the judicial discretion in the matter of admitting or rejecting the confession. The value of the evidence as to the confession, just like any other evidence, depend upon the veracity of the witness to whom it is made, and it is not invariable rule of the court should not accept the evidence if not the actual word but the substance were given. So that is the importance or the significance of this word appears to the court. Now come to the another phrase used in the section 24, that appears to the court to have been caused by any inducement, threat, or promise having reference to the charged against the accused. having reference to the charge against the accused. And what does it mean, having reference to charge against the accused? Charge means the criminal charge of an offense in a criminal proceeding. A confession made by inducement relating to some collateral matter unconnected with the charge are excluded by the evidence. So this inducement, this threat, this promise, etc., has to be in reference to the charge in which he is framed. Okay, and then the against accused person. Accused person means the person against whom the investigation has started, or any formal complaint has been made. So that is the meaning of the word the accused person. Then, to give the accused person ground which would appear to him reasonable for sporting that making it would gain any advantage or avoid any evil of temporal nature in respect to the proceeding against him, and proceeding from a person in authority. So person in authority, what does means the person of authority? The expression does not mean person having the control over the prosecution of the accused. The test appeared to have been the person in authority to the inference that the matter under inquiry, for example, person engaging in apprehension, detention, etc. But the person, like the um, member of the panchayat, he cannot be the person in the authority. So person in the authority does not mean only the prosecutor, but the person who is who is detaining this person, who is apprehending this person, who is doing the interrogation, etc. All are the person in authority. And then again, the any advantage or avoid evil of temporal nature. Here temporal nature means worldly nature and not of spiritual. Suppose someone says कि मर्डर कर दिया आपने अपनी बेटी का, एंड अब तो आप सच बता दो, ऊपर जाके आपको जो है भगवान जन्नत नसीब करेगा, या वट एवर दैट स्पिरिचुअल शांति मिलेगी, आपकी आत्मा सही से जाएगी. So that is something that is spiritual or religious, and that type of the inducement would not be the temporal nature. So the word written as that any advantage or devoid any evil of temporal nature means that inducement must be of worldly nature. Worldly nature is dunya ka, and not of spiritual and religious. A moral exhortation of telling the truth is not objectionable. कि आपको सच्चाई बतानी होगी, God is watching you. कब तक आप अपने पाप छिपाओगे? So this type of the thing would not amount to any this thing. Okay. So the important terminology, important things that related to the confession also we have discussed, and important term used in the section 24 also we have discussed. Now come to the case on the section 24, Veera Ibrahim versus state of Maharashtra. We will discuss it. But before that, I'm giving you 1 minute. If you have any doubt or if you want to ask any question from whatever we have discussed, the first thing is that whether the incriminating conduct amount to confession. The second is the scope of Article 20, Clause 3 in the confession. The next is what is judicial confession and its evidentiary value. Then next is what is extrajudicial confession and its evidentiary value. Then what is the the acknowledgement of the subordinate fact. Then the sixth one is what is retracted confession and its evidentiary value. And the seventh is one is that the terms like it appears to be accused person in reference to the charge and of the temporal nature in the section 24. These 7 things we have discussed today in our lecture. If you have any question, any doubt, any type of query, you please ask me, and then I will start this case on the section 24, Veera Ibrahim versus State of Maharashtra. Yes, guys, please. Mr. Abhimanyu,
Yes, sir.
कोई क्वेश्चन, कोई क्वेरी, कोई किसी तरह का क्लैरिफिकेशन यू वांट?
No, sir.
Okay. So, guys, come to this case, Veera Ibrahim versus State of Maharashtra. You know, I always say that on the 5 things we have to discuss every case: facts, case history, issue, arguments, decision. So, facts of this case are that on, yeah, just give me 1 minute. That on the 12th December 1967, there was a truck loaded with certain items and found to contain contraband goods by the custom authorities were surreptitiously loaded in the truck under the cover of darkness in Reti Bandar, that means seashore, from side of seaside wall in presence of the appellant, Veera Ibrahim. And thereafter the first accused took the wheel while the appellant sat by his side in the truck and drove towards the Sandhurst railway station. It was further admitted that some Bania paid 2000 rupees to the appellant, which was meant to given to the driver of the truck. Unfortunately, the truck skidded near the Dongri police station and come to the stop. सिंपल फैक्ट है कि 12 दिसंबर 1967 की रात को मिस्टर वीरा इब्राहिम और उसका साथी दोनों रात के घने अंधेरे में सी साइड के पास ट्रक में कुछ सामान लोड किए और उसको लेके वो जा रहे थे। एंड किसी बनिए ने जिसका सामान था, उन्होंने 2000 रुपये भी दिए उस समय में, आज भी 2000 की वैल्यू है, कि वीरा इब्राहिम आप इस ड्राइवर को देना है। एंड देन व्हाट हैपेंड दैट अनफॉर्चुनेटली ट्रक स्कीडेड, और वो टकरा गया फिसल के और बड़ा एकदम से आवाज हुआ। एंड इट वाज नियर द पुलिस स्टेशन। पुलिस ऑफिसर केम आउटसाइड, देखा सामान भी भरा हुआ है, तो जब्त वक्त कर लिया। एंड देन the police seized the truck and the goods. In short, the appellant had clearly admitted that these packaging containing the contraband goods were imported surreptitiously from Reti Bandar under the cover of darkness. और उसने एक्सेप्ट भी किया कि हाँ, हम लोग इसको ले जा रहे थे सी शोर से। And it was further established the horse that the statement of the plant that these packages and opening by the custom officer were found to be the contraband of goods of foreign make. So this much of the things. Now what happened that जब तक ये ट्रक टकरा गया, उसमें से सामान हुआ, पुलिस ने वो सीज कर लिया। एंड ऑन अंडर सेक्शन 124 ऑफ द बॉम्बे पुलिस, उनको लगा कि सामान जो है कुछ अलग तरह का है। उसने सेक्शन 124 में, जो कि ये कहता है कि whoever is in the possession or conveys in any manner or offer for sale or pawn anything which there is a reason to believe is a stolen property fraudulently obtained shall, if he fail to amount for such possession, to act to the satisfaction of magistrate or contravention, etc. So police under section 124 of the Bombay Police Act has made the panchnama of the package कि इतने पैकेट हैं, ये सारा बना दे। And then they inform to the custom officer. Now there is the role of the custom officer, that the custom officer, then there is the statement taken by the accused, and that statement was under section 108 of the Custom Act. So the custom officer recorded the statement under section 108 of the appellant under Custom Act 1962, and then conviction started. Then what happened, that in the conviction before the chief presidency magistrate, this Mr. Veera Ibrahim and his fellow Abdul Umrav Rauf both were convicted under section 135A and section 135B of the Custom Act 1962, because the items in those packages, उन पैकेट्स में देर वर एंड कॉन्ट्राबैंड गुड्स, सामान था जो विदेश का बना हुआ था, विदाउट पेइंग द कस्टम ड्यूटी, you know, they were transporting these items. And under section 5 of Import and Export Control Act 1947. Okay, on the conviction, now these are the facts. Now these persons were convicted, Veera Ibrahim and his fellow, and on that conviction under three provisions, one under section 135A and section 135B of the Custom Act 1962, and section 5 of the Import and Export Control Act 1947. Okay, आजकल फेमा है ना फॉरेन एक्सचेंज एंड मैनेजमेंट एक्ट. अब क्या हुआ, कन्विक्शन के बाद में दे वेंट टू द हाई कोर्ट, एंड हाई कोर्ट हैज एक्विटेड in the section 135A and section 5. That offense of section 5 has not been established. Section 5 of the Import Export Control Act 1947, and offense of section 135A was also not established. But section 135B of the Custom Act 1962, that is, on that ground, on that offense, they were convicted. And the High Court also gave the certificate under Article 134(1)(c) of the Constitution. And on that application, the Veera Ibrahim approached to the Supreme Court. So this judgment we have in the Supreme Court. In the certificate, when it was given by the High Court, there was a question that the statement that was recorded by the custom officer under section 108 of the Custom Act 1962, this section in itself is ultra vires the provision of clause 3 of the Article 20, because it is hit by Article 20 clause 3. But what happened, that Mr. Chaudhary, appearing for the appellant, does not press this question, rather he did the discussion on the some other provision, some other grounds. The first is that the statement that is recorded under section 108 of the Custom Act is hit by first Article 20 clause 3, second by section 24 of the Indian Evidence Act. Means, in the simple word, the statement that became important base for conviction of these person under section 108 of the Custom Act 1962, according to the appellant counsel, is argument that this statement is hit by section 24 and it should be rejected. अब अगर वो statement reject कर देते हैं, so the prosecution would fail to prove his case. Okay. So the arguments, the third is the issue is whether the conviction under section 135A is proper or not, or the conviction under section 135 of the Custom Act 1962 in light of the statement recorded under section 108, whether the statement recorded is admissible or not admissible. And the council want to prove that it is hit by section 24 of the Indian Evidence Act. And so it is not relevant, it is irrelevant, and so there is no case of admissibility. Also has said that it is also hit by Article 20 Clause 3. And the argument from the prosecution side that no, because if you see the each and every ingredients of the section 24, in that light, the first thing is that the statement recorded under section 108 has to be confession. Confession hoga tabhi to. If it is not a confession, then section 24 will not apply. If it is not a confession, Article 20 Clause 3 would not apply. And so the whole argument happened on that. And then court read that Clause 3 of Article 20 said that no person accused of any offense shall be compelled to be a witness against himself. And section 108 of Custom Act, under which the statement was recorded, if you see the whole circumstances, para 11 of the case, para 11 page number 61 is dealing about that in respect of that offense, the police did not register any case or enter the FIR, which normally furnish a foundation for commencing the police investigation. The police did not open the packages or prepare the inventories of the goods packed therein. Indeed, the police appear to have dropped further proceeding. They did not take any step for prosecuting the appellant, even for the offense under the Bombay Police Act. उन्होंने क्या किया? ना तो उन्होंने कोई आगे प्रेसिडिंग की, ना और कुछ किया, ना इवन बॉम्बे पुलिस एक्ट के अंडर कुछ किया. उन्होंने इन्फॉर्म किया कस्टम ऑफिसर्स को. कोई FIR लॉज नहीं हुई, कोई केस रजिस्टर नहीं हुआ. They informed the custom authorities. Custom authorities officer opened the package, inspected the goods, and on finding them contraband goods, seized them under Panchnama. The custom authorities called the appellant and his companion to custom house, took them in custody, and after due compliance with the requirement of the law, the inspector of custom questioned the appellant and recorded his statement under section 108 of the Custom Act. Under the circumstances, it was manifest that at the time when the custom officer recorded the statement of the appellant, these accused, the latter was not formally accused of the offense. They were not accused of the offense when the statement was recorded under section 108 of the Custom Act. And so High Court, Supreme Court is saying that High Court was right in holding that the statement recorded by the inspector of the custom is not hit by Article 20 Clause 3. I have read Article 20 Clause 3 earlier, that no person accused of an offense. And here, Veera, Ibrahim and his fellow were not accused of an offense at the time when the custom officer has recorded their statement. Okay. Now come to the second arguments made by the appellant counsel, that statement under section 108 amount to the confession and hit by section 24 of the Evidence Act. On the para number 14, page number 62, you will find it, that to attract the prohibition enacted in section 24 of the Evidence Act, these facts must be established. And what are these facts? 6 facts. First, that the statement in the question is a confession. Confession honi chahiye, as in Pakla Narayan Swami, admitting the guilt in itself, or at any rate admitting all fact constitute the offense. First, the statement in question is a confession. Second, such confession has been made by the accused person. That means accused person means उस समय उसके ऊपर उसी तरह का FIR केस रजिस्टर होना चाहिए. accused person का मतलब है. कोई कहेगा सर कन्फेशन है तो accused person ही होगा. accused person means at the relevant time he is making the confession, there is a case registered against himself. Yes, Mr. Arshad. And that it has been made to the person in the authority. Person in the authority होना चाहिए जो inducement देगा. Then the confession has been obtained by reason of inducement, threat and promise for proceeding from the person in authority. So जो inducement और threat से जो confession ले रहा है वो भी person in authority होना चाहिए. Like we discussed that the member of the panchayat, he cannot be the person in authority. And the fifth one is such inducement threat must have reference to the charge against the accused. Inducement दे रहा है आपको 5,000 रुपए दे देंगे, that would not be in reference to the charge or some other thing with respect to that must be in reference to the charge to which he is accused. And the sixth one is the inducement threat or promise must be in opinion of the court is sufficient to give the accused person ground which would appear to him reasonable for supposing that making it he would gain advantage or avoid any evil of a temporal nature in reference to proceeding against him. In para number 15, the court has observed that first point that there is a confession, the fourth point that it was obtained by reason of inducement threat, and the sixth point that it was because it appears to the court that this type of the confession by the accused person because of avoiding any evil in temporal nature. All these things has to be established by the defense to take the benefit of the section 24. And so these has not been established. Firstly, the statement in the question is not the confession. Within the contemplation of section 24, it is now well settled that the statement, in order to amount a confession, must either admit in terms of the offense or at the rate substantially all the fact which constitute the offense. An admission of incriminating fact, howsoever grave, is not a confession. The perusal of the statement exhibit number 1, जो जब आप कोर्ट में जाते हो and whatever the document you put for court to appraise, कोर्ट देखेगा ना उन डॉक्यूमेंट तो उनको एग्जिबिट लिखते हैं, एग्जिबिट 1, 2. जब आप प्रोसिक्यूशन की साइड से हो तो PW लिख के विटनेसेस को PW और exhibit P, exhibit 1, exhibit 2, etc. So the exhibit 1 is basically related to the statement recorded under section 108 in this case. And if you read that, it says that deponent claimed that he was not aware that the package which were loaded in the truck were contraband goods and alleged that goods were not loaded under his instruction. The deponent claimed to be an innocent traveler in his truck when he said that I did not ask Mullaji, the driver, what goods were being loaded in his lorry. Mullaji was only my friend and I was not I was aware of his malafide activity. Okay. And then para number 17, 18 also you can read it. But only on the ground that it is not a confession also means that section 24 would not be applicable. And in the para number 21, while it may be considered that a person summoned by a officer of custom to make the statement under section 108 of the Custom Act is under the compulsion of the law to state the truth. Yes, compulsion तो है, उसको सच्चाई बोलनी है. सच्चाई नहीं बोलेगा तो there would be the case of perjury. But this compulsion would not amount to something like threat, inducement, or promise from the person in authority, which is contemplated under section 24. That under the summon, when a person is called and his statement is recorded, he is bound to make the truth. झूठ बोल रहा है वो बात अलग है, but he is bound to tell the truth. But that does not mean that there is threat or promise as contemplated in section 24. Thirdly, para number 22, mere fact that Inspector of Custom had, before recording the statement, warned the deponent the possibility of his prosecution for perjury in the case also did not amount to the statement truthfully, cannot be construed as a truth held out by the officer which could have been reasonably caused. Abhimanyu, switch off your mic. Yeah. Which would have been reasonably caused by the person making the statement to suppose that he would, making the statement, gain any advantage or devoid any evil of temporal nature in reference to the precedent. So even the argument by the defense that my client, when appear before the custom officer, the Inspector of Custom officer has warned that he has to tell the truth, otherwise there would be the case of perjury. This also would not amount to threat, promise, or inducement as contemplated by section 24. And so, in the para number 25 at last, I'm reading that the circumstances established unmistakably and irresistibly pointed out the conclusion that appellant was knowingly concerned in a fraudulent attempt at evasion, if not fraudulent evasion, of duly chargeable on those contraband goods, and in that result, appeal fails and dismissed. Why the appeal fails? Why the decision? Because neither it is hit by Article 20, Clause 3, because this statement made under Section 108 of the Custom Act 1962, at that time, the person was not the accused. There was no formal FIR, there was no case lodged against him. Okay? On the benefit of section 24, section 24 is also not attracting, because that make the confession as irrelevant. The first thing, that the statement by the person under section 108, the exhibit 1, is not a confession. Confession in it. Second, that there is no inducement, no threat or promise has been given by the person in authority. Even if inspector has warned that he accused has to tell the truth, otherwise the case of perjury would be lodged against himself, that would also not amounted to threat, inducement, and promise. And because none of the argument has been proved by the defense, and so appeal fails and dismissed. Okay, have you got this case, or do you have any question on this case? Yes, Mr. Rohit Kumar. कोई क्वेश्चन, कोई केस? Mr. Aman, do you have any query on from this case, or have you understood this case properly? Abhimanyu, you have to take the lead. Please tell me. Yes, Mr. Abhimanyu. And he's also not telling. Vishwajit. Mr. Vishwajit. No question? Okay.
No, sir.
Vishwajit, can we further discuss section 25, etc., or should I stop here?
Sir, I think we should stop.
Okay. So guys, you have to read section 25 and 26. Both section 25 and 26 are related to the confession that somehow related to police officer, or the section 25 making inadmissible all the confession made to the police officer. चाहे वो पुलिस ऑफिसर अथॉरिटी में हो, आपके खिलाफ चार्जशीट कर रहा हो, उसके ऊपर खाकी वर्दी वाला होना चाहिए, कन्फेशन आपकी इनएडमिसिबल होगी. ओके. एंड सेक्शन 26 इज व्हेन यू आर इन द कस्टडी. पुलिस ऑफिसर को तो कन्फेशन करते हो तो सेक्शन 25 में इनएडमिसिबल है, बट इन द कस्टडी to other person also, if you make the confession, that extrajudicial confession, that would also would not be admissible. Only the confession made before the judicial magistrate would be admissible. But if you see section 25 clubbing with section 26, that even in the presence of magistrate you make the statement to police officer, again not relevant. पुलिस ऑफिसर को तो कुछ भी हो. एंड रीजन ऐसा नहीं, एक बार तो पुलिस डिपार्टमेंट वाले इस सेक्शन से बहुत परेशान हो गए, चिढ़ गए. किसी ने लो क्लासेस में बता दिया, किसी प्रोफेसर ने, कि नहीं नहीं आपको ट्रूथफुलनेस नहीं माना जाता. एंड सो दे अप्रोच टू द कोर्ट, दे रोट द लेटर टू द डिफरेंट अथॉरिटीज. सेक्शन 25 is derogatory to them. But the reason is that this rule is to stop the extortion of the confession by the police by malpractices. ताकि पुलिस जो है वो एक्सटोर्शन करके माल प्रैक्टिसेस यूज करके कन्फेशन को एक्सटोर्ट ना करें, एंड टू अवॉइड द डेंजर ऑफ एडमिटिंग द फॉल्स कन्फेशन. सो ओनली दैट मच ऑफ रीजन दिस सेक्शन 25 is not showing the police officers or the police department in the dim light or derogatory. That is misinterpretation. So this type of the misconception was there. The only thing is that it stops the police officers for using the malpractices to extort the confession and to stop believing on the false confession, etc. So that is only the reason. Don't see in that thing. So section 25, 26 and 27, all these sections are clubbing to each other, interrelated, but that does not mean that they overlap. Section 25 and 26 does not overlap, yes, but they are connected. Okay. So with this remark, I stop here. And the case Agnu Nagesha was the state of Bihar. I wanted to discuss that case also today, but because of our low pace, we could not do that. So in the next class we will complete that. So with this, today class is over from my point. I'm giving you 1 minute. So if you have any question, query related to this class or as in journal, you can ask me.